So if you're homeless through a disaster like a fire or flood, you're automatically in priority need. So if that's true, would you be in priority need if you intentionally set fire to your own home and thus became homeless through the fire? Now, your knee-jerk reaction to that is probably going to be, of course not, surely you can't be in priority need. My response to that is actually, show me where it says that would not be the case. Because as far as I can tell, that question is left open in current law as it is. Now, obviously, I'm not saying that burning your own house down is a good idea, but in order to answer this question, I've been on a bit of an interesting journey through a few cases and just kind of learned a few bits that might also be interesting. If you want to fast forward to the end of the video, essentially the answer is you probably won't be in priority need, but you probably need to go to court to actually settle that. But to get to that point, as I say, there's actually some interesting bits and pieces that help understand how housing law all fits together. And so the question itself came out of a webinar I did a few months ago with criminal justice workers who often work with people with arson convictions, so it's not unusual. And that's kind of where they were coming from, so they're just trying to make sense of it all, really. And I didn't know the answer, actually. As I say, my first guess was, well, as far as I can tell, there's nothing saying they wouldn't be in priority need, because it would be a fire, obviously, that's caused that person to become homeless, and there's no need for it to be a force majeure or an act of God or something for it to make it that kind of disaster. So, for example, you might have a fire which is intentionally set by a neighbour. In that situation, you would, of course, be in priority need. So I started this kind of little adventure by asking a question in the Facebook group I run called Homelessness Best Practice, and I learned a couple of things straight away there, because the way I asked the question was to add in an additional bit of complexity to kind of make it actually make sense. And so the hypothetical situation I put forward in the group was, if I was unable to pay my rent, so legally I'm homeless, and I then set fire to my house because I'm an absolute nightmare, would I be in priority need and not intentionally homeless? Now you might think, why am I adding this bit in about intentional homelessness? It kind of just helps make sense of a few other bits as well. And one of the things I learned from the group was a lot of people would jump in with that knee-jerk reaction and say, of course you wouldn't be in priority need and you would be intentionally homeless. Many of the people in the group are housing officers, I believe, and I think some of the people giving that answer were housing officers. And so, big picture for a moment, one of the things that made me think about was just kind of, realising, or, kind of realising afresh that housing officers, something about the way the role works, the pressures they're under, the way the system makes you make decisions, does not leave space for curiosity. So, in one sense, when I went back to those people and said, show me where it says that, they weren't able to give an obvious answer. So it seemed to me to be something which was, as I say, that knee-jerk response rather than actually understanding how the law worked. And in one sense, it opens up this problem that we have within housing law, that people seem to be willing to ascribe more certainty to their answers than they're actually, is actually justified. As in they basically say more than what they actually know. And there is this kind of problem within the sector that people, it's kind of not all right to not know the answer. It's not okay to kind of say, well, I don't know, I'm going to go find out, basically. So one of the reasons I'm doing this video is just kind of give an example of how you can learn stuff by going down that route. Because what I can say from the scenario I put forward is that you would not be intentionally homeless, as weird as that sounds, because there's 3 criteria that have to be met to be intentionally homeless. You have to do something intentionally which leads to the loss of your accommodation, which, if you set fire to your own house, that obviously would be an intentional act, assuming you had capacity, you had mental capacity and so on. But that's only one of the 3 criteria. The second criteria is the accommodation must be available for your occupation, which it probably will be, so this probably won't be very relevant. But the third one would be, it must be reasonable to continue to occupy that accommodation. And that's why I introduced this idea of not being able to afford the home, because if you genuinely can't afford your home, it's not reasonable to continue to occupy, and therefore you cannot be found intentionally homeless. But this has a little sting in its tail as well, which is kind of what I'm going to kind of work through to kind of get this answer. So, as I say, there's no case law as far as we know that there's a precedent set out that says you would or would not be in priority need if you set fire to your own house. But there's some helpful cases that are out there that might kind of give us an indication. So the first case is a case called Bradage v Bristol. I was not able to find a free transcript of it on the internet, so I'm really kind of finding this stuff out because it was mentioned in another case called Higgs v Brighton. But if we start with the Bradage case, the question in this case was, if someone was to go on holiday, a tenant was to go on holiday, they come back, they find the locks have been changed by the landlord, they've been illegally evicted, and the landlord's now moved in a new family who are now living there, so there's no way of kind of getting that accommodation back. would that be something that would come under this umbrella of disaster that we see in the legislation? So yeah, that's kind of the question that was set out. And in one sense, I mean, it's a little bit unsatisfactory, but essentially the outcome of that case was to say that no, an illegal eviction would not be something which Parliament intended to come under this ambit of a disaster. I think, reading between the lines of what I've been able to gather, that's because there would be recourse to prosecute the landlord and potentially pursue compensation. I think that's the kind of reasoning behind it. So illegal evictions are not a disaster that might make you in priority need automatically. But we saw another case in 2003, I think it was, Higgs v Brighton, which comes tantalisingly close to answering this question for us actually, but not quite. And this was a case of a guy, he lived on a caravan on, I think, wasteland or something. He didn't have a legal right to be there. He went to walk his dogs one day, comes back, and the caravan's been stolen. There's no trace of it, they never find it. And so the question was, would this be something that would come under this ambit of a disaster? And in this case, it was a yes-no response. So essentially the answer is, yes, that would be the kind of thing that could be classed as a disaster. And the judge even says that, you know, what's the difference? If the guy went for a walk with his dogs and came back and his caravan had been deliberately burnt down by their neighbours or something, clearly that would have the same effect as if the caravan had been completely stolen. So for that reason, this was seen to be something that could amount to a disaster and therefore confer a priority need, except that the wording of the legislation says that you're in priority need if you are homeless because of the disaster. And in this case, he was not homeless because of the disaster, he was already legally homeless, because although he had a movable structure which he was able to, was classed as accommodation, he didn't have anywhere to legally put it. Therefore he was already homeless, and so the subsequent theft of his caravan wasn't relevant, and so he was not automatically in priority need. Although, as I say, the case does set this precedent to say if you had a caravan that was on land that you legally allowed to be on and it was stolen, then yes, that would be a disaster that would make you in priority need. So within the case, as I say, it comes tantalisingly close to giving us an answer about this overall question, because it basically, in the example it gives about, if the guy went for a walk with his dogs and his neighbour had set fire to his caravan deliberately, that would have the same outcome as it being stolen. The way it's worded clearly has this intention of someone who had not done anything to deserve or kind of amount to some sort of intentional act to make that happen. So this was, in one sense, the idea being here that you are a victim to something outside of your control, whether it be a natural disaster, whether it be something like Grenfell, whether it be something like a horrible neighbour who set fire to your caravan or something. So it kind of infers that from that, although it doesn't answer our question explicitly. I think that comes about as close as you're going to get to. But if we go back to our scenario and ask the question, would you be in priority need automatically if you set fire to your own home when you couldn't afford the accommodation? The answer actually would be definitely no, but not for the reason you think it would be the case. Because in that situation where I was not able to afford my rent, the subsequent fire of me setting fire to my own home would be something which didn't actually cause me to become homeless. I was already legally homeless because of the unaffordability. And so in one sense it wouldn't even be engaged in the question really, it just wouldn't get that far. In different circumstances, I think, let's say I was able to afford my home, I burnt my house down deliberately, approached a local authority and basically argued that I was in priority need. Although there is nowhere which explicitly says, as far as I know, that you would not be in priority need, ultimately the council would obviously be reasonable to challenge that decision and basically let it go to court. And it would be, unimaginable that the judge would not say something like, when Parliament set this legislation out back in 1977, this goes back to, clearly they did not intend it to be, kind of allow people to go and set fire to their own homes to get priority need status. So I think that would be the kind of short answer. But as you can see, it kind of brings up these other different ways that the housing law comes into, kind of works in practice. And it has relevance in kind of a not a great way, because the wording of this priority need through disaster is similar to the wording around priority need through domestic abuse, because essentially you are in priority need automatically if you are homeless because of domestic abuse. Now, fortunately, I think most housing officers probably either don't kind of think in these terms, or they just don't know the law well enough to know it's a problem. But I'm sure this does come up, because in the same way that setting fire to my house when I couldn't afford it doesn't lead me to be in priority need because I was already homeless, let alone the actual argument about the actual fire, If you are already homeless because of unaffordability or severe disrepair or unsuitability of accommodation or something like that, and then you were subject to domestic abuse and it was likely to continue, therefore you'd meet that criteria of being homeless through that as well, technically speaking, you would not automatically be in priority need because it wasn't the cause of your homelessness. So this is one of maybe 3 different situations when you're not necessarily in priority need automatically through domestic abuse. Now, you almost certainly will be, because you would simply fall back on the vulnerability argument, although unfortunately that would make it a bit more convoluted to get to the right outcome. The fact that the Domestic Abuse Act changed this and made it an automatic criteria in most cases around domestic abuse was because as a society we have rightly recognised that domestic abuse has far-reaching, obvious and not obvious consequences to someone's health, well-being, resilience, all those kinds of things. So as I say, I don't think it would be a problem necessarily, but it does mean if you're an advocate or if you're homeless yourself through domestic abuse, it's worth just bearing in mind. I don't think it comes up in probably 90% of cases. I don't think housing officers either are that unpleasant or are that knowledgeable about the way the law actually works to actually kind of play this argument. But as I say, I'm sure it does come up sometimes. So it's just kind of worth being aware of, seeing how these different things kind of work and how the wording that sets up these principles is actually really important to understand. Interested, by the way, to say if anyone's got any kind of similar silly hypothetical questions to ask that, kind of maybe look like loopholes or whatever, put them in the comments, because I'd be interested to kind of look at these kind of examples to see what we can learn from them.